Hi, this is Nam from Easy Sunday Club.
And it's Cathy.
And today we're going to talk about copyright.
Yep.
And this is our fourth video in our legal series. First video was about what entity you should form if you're an artist. Second one was about common business permits that you would need as an artist. Third one was about trademarks. And this one's about copyright.
This is actually my favorite topic out of the four.
Yeah, and probably the most applicable for artists.
Yes.
But one thing, since this is a legal video, I want to let you know that as a disclaimer, this is just for informational or educational purposes only and for your entertainment if you find it entertaining. And please don't sue us.
And Nam is not looking for clients, so this is not a lead generation video to get get clients.
Yeah.
He's not open for business.
Yeah.
He's exclusively my lawyer.
We do have a boring agenda, and that is an intro. We're going to talk about what a copyright is. Do I need to get one? How do you get one? What happens if someone's infringing on your copyright? Our own copyright and infringement experience. And then we're going to end with a conclusion.
Okay, let's get to the low-hanging fruit. Everybody's wondering, what's a copyright? Do I need to get one?
I'll give you the boring definition of what a copyright is. So a copyright protects an expression of an idea by creating a public record, and it allows you to take legal action if used without your permission. So these are a bunch of simple words, but altogether it might sound like junk. What I want to do is talk about some use cases. So for example, you can get a copyright in a written work, which could be a song, play, or choreography. It can be in art, which is what we want to talk about today, which are photos, paintings, or sculptures. It can be software, and it can also be architectural plans and drawings. However, with a copyright, there are some things you cannot copyright. For example, you can't copyright a fact, a concept, a slogan, methods of operation, names, or public domain.
So if I think I'm painting watercolor in this very unique way, that's not a copyrightable thing.
Yeah, that's a method, but if it is so unique and so technical, it might be something that you can patent. What concepts that are commonly mistaken or confused with are with trademark versus copyright versus patent, which I can get into next. The legal terms that are sometimes incorrectly used interchangeably are copyright, patent, and trademark. And I'll go through the differences by comparing them all side by side. So, like I said, a copyright protects original works of your authorship and can be literary, dramatic, musical, artistic, etc. A patent is a limited duration property right to an invention, so that can be a machine, an algorithm, a new method, which you were using as an example, manufactured products, industrial processes, chemical compositions, and a trademark that protects a distinctive word, phrase, symbols, your logo, and its main purpose is to distinguish sources of goods and services between two different parties.
So just to wrap it up with a nice little bow for the artists out there, copyright is like any piece of artwork that I made.
Yeah, that you want to protect.
Patent would be in very exceptional cases. Let's say I'm making my own watercolor paint and the pigments I'm using, it's like this special combination.
The method. Or you come up with a new amazing product, like some sort of crazy zero gravity weighted blanket,
that has some kind of technical component to it. And then trademark is my Easy Sunday Club company name as well as the logo.
Correct. And depending on which right you want to protect, you have to file it in different offices. For copyright, which is the one that we're talking about today, it's with the U.S. Copyright Office. And with patent and trademark, you will file it with the U.S. Patent and Trademark Office. And also with each one of these rights, you have different requirements, applications, fees, and the length of time you can protect that right.
Sounds like I need a lawyer for this.
Yeah, super exciting stuff. Very much so exciting that you'd be willing to spend $200,000 to go to school for 3 years and take a bar for.
So sounds cynical.
Yeah. So the next thing is, do I need a copyright? In general, if you are an artist starting out and you're already overwhelmed with your business and creating the art itself, and you have a strong critical voice and you're already crapping on your work all the time, just focus on your art, trying to create good art and trying to get that out. Don't worry about the copywriting of it. The reason why is because a copyright is automatically acquired from your work the moment you create it and make it tangible. So the moment you take it from your head and put it on a piece of paper, you already have a right to that work because you created it. By filing it with the US Copyright Office, you are just formalizing it and you are registering it with US Copyright Office. If someone else is using it and you want to sue them, you can show proof that you have a right to it. For example, you don't need a driver's license or a social security number to prove that you're a human being. You're already a human being the moment you are born. But the social security number or the driver's license kind of registers you in this database to formalize it.
It legitimizes your existence as a human being.
Correct.
Instead of a droid or something.
Yes, I only knew you were a real person.
Because you see my driver's license.
Yeah, because I saw your driver's license.
Not because you saw me in person.
Yeah, and real California ID.
Okay,
Correct.
in all seriousness, I have 2 questions though.
Yeah.
And it's from like questions I've gotten from other artists. One is, as an artist, obviously we create all these different bodies of work. Can you apply for a copyright for any work that you create, or you have to register bodies of work individually? Like, how specific does it have to be?
Either or, you can do both. So you can register a copyright for each and every one of piece of your art. For example, with Cathy's alphabet blanket, I just copywrote the entire blanket and the collage of designs because I didn't want to go and file 26 different copyrights for each one of the individual paintings.
Okay.
So you have to make a decision as an artist. Are you in the business of being an administrator and filing a bunch of copyrights, or are you in the business of creating art and selling that art?
Okay.
Because like if you want to spend all your time filing for copyrights all day, you can do that if you want.
Okay.
But what I would recommend is some of the considerations I wrote out. Which one of your arts are you planning to make copy, sell, distribute, or make derivative artworks out of? Derivative means you make a painting of that giraffe and you want to put it on a card and a t-shirt and on a toy, or the ones that are your halo product, the ones that are the most important and the ones that you think will be most likely to be copied, maybe those are the ones that you should focus that administrative effort on making a copyright on. Is there a risk of work being used without your permission? Like your idea is so unique or clever. Are you planning to sue someone and you want to show that you have that work of art registered before they do? Even if used without permission, do you have the resources to sue?
That kind of answered my second question, but I'll ask it anyway. I also get DMs from artists who say the work has already been physically made, but they're worried about if they share it to Instagram. They've heard horror stories of their work being reposted or copied by other artists who have the audacity to like sell their work, even though it's not a direct copy. It's like very, very heavily influenced. So in that case, like, what do you tell them? How much of that fear is justified? And that's not really a legal advice, but just from someone who's like a little more removed from it, tell me what you would tell me if I was that artist.
If someone were to ask me that, I'm really afraid to post my work because someone might steal it. In general, I'm a little bit more risk-taking when it comes to that than risk-adverse. The only way that our personal company has been able to move forward is by selling, showing, marketing, and sharing our work. And it's really a hard thing to do. It's actually more of an emotional barrier than a legal barrier, in my opinion. If someone steals or copies your work, so what? What are you going to do? Sue them? It's so expensive to sue. Let's just take this down another click. It's like, I'm so afraid of someone stealing my art. So what are you going to do? Never share your art or never show it anywhere because you're afraid someone's going to copy it? It can be a little bit paranoid to always think like that, right? Mm-hmm. I think part of being an artist and sharing your work out there is taking that risk. Sometimes when that does happen to us, I look at it as somewhat flattery.
Because imitation is the
greatest form of flattery.
Flattery.
If you think about it, if someone's not copying your work, then that means it's not really resonating with them. They're only like copying work if it's resonating. So if you see a lot of work being copied, that means that you may be onto something, and that's actually a good signal.
Yeah, and like another point is if someone's always in the business of copying other people's work, like you're always a step ahead of them, right? Because you're the one creating the original work. And the reason why I brought up that question, it kind of parlays into our own experience of being copyright. So we overcame the fear, put my work out there, and it did get copied and it did get sold by someone else. But it's not end of the world. We're still here. And I still have a business.
Yeah, and we'll talk about how we dealt with that. So just some more boring stuff about copyrights, like how long does it last? Generally, the author's life plus 70 years. If it's anonymous or made for hire work, it's the shorter of 95 years from when it was first published or 120 years from creation.
It's basically a lifetime.
Yeah, pretty much. Whatever's shorter. Before 1978, they had different rules for that, so you'll have to look that up. But what I want to give you a high level view of is just like, hey, this is in general how long it lasts, right?
Okay.
So next is, how do I get a copyright? First thing is that you don't need an attorney. I've said this before in the other videos, attorneys are pretty useless. The only reason why you would need an attorney for a copyright is if you don't want to do it yourself and you want to delegate it to someone who has experience doing it. Even then, attorneys can make mistakes, but it's pretty much an administrative thing that you can do yourself. If an attorney does do it, they usually charge anywhere from $150 to $350 an hour, sometimes even more. But there's also cheaper routes that you can go about. You can go through LegalZoom or Rocket Lawyer, and they'll prepare some forms and give you customer support in order to help you through this process. If you do want to do it yourself, then you go to the US Copyright Office. The link is right there, and you pay the fee. You fill out the form, wait until they get back to you to make sure they copywrote it. And that's it, you got it. Next part is I'm gonna just show you like a quick screen capture of like some of the fields that you have to fill out with the copyright registration form.
Okay.
So in order to file with the US Copyright Office, you go to their website, copyright.gov, and on the front page you'll see a couple of options. The one that we want is to register a copyright, and then you will log into the Electric Copyright Office and you will go ahead and register electronically. Instead of walking you through the electronic copyright form, I'm just going to show you the forms in general. So these are the basic forms for the US Copyright Office. This is the website, www.copyright.gov/forms. And these are your basic registration options: literary form, visual form, single serials, which is when you want to copyright magazine periodicals or newspapers, performing arts, and sound recording. I'm going to click on the visual form because this is what most artists will need to register. First page is just basic information. You can read through it and get a feel of it. Second page as well. And then you get to the actual form, and it's pretty straightforward. You go to title of work, fill this out, nature of work, and there are additional instructions to give you examples of what this means. Previous or alternative titles, publication as a contribution. This is where you put in your information, and if it is a business, then you'll be putting it as that. For Cathy, I put her first and last name. For nature of authorship, the type of art that you are submitting, yours is going to be a two-dimensional artwork if it's a graphic art, watercolor, or painting. But you can see that there are a couple different types. For nature of authorship, again, two-dimensional artwork. Then you put the date and year of when this occurred. Copyright claimant, you should put yourself. Fill out this information to talk about previous registration. This part asks if it's a derivative work or a compilation. And that's pretty much it. You sign at the bottom and then you submit it, and you pretty much just wait and you pay your fees. So after you do that, then you get your copyright, and then you can search yourself up in the database. So not super difficult. So the fun part, what happens if someone is using your work? So I'm going to talk about your options first, and then I'm going to go through our kind of experience of having our art being copied. So first thing is copyright infringement. So let's say someone is using your art and saying it's theirs. What can you do? First option I always give to clients is you can do nothing. You can just ignore it and just say like, these people are a bunch of scam artists. They can't sell my art the way that I do, and just leave it alone and move on with your life, right? Second thing that you can do is you can send a cease and desist letter to the person who's stealing your art or to the company that's using your art without your permission. And basically what a cease and desist letter is that it tells the company or the person infringing on your art, hey, stop doing that. I have a right to this art. If you keep on doing it, I'll sue you. In order to write one, there's tons of examples and and templates online, and all you have to do is just fill in the blanks. Dirty secret for lawyers is that we don't like to reinvent the wheel. We just like to take templates, fill it in, and then charge our client $150 to $350 an hour to do this. Once you send the letter, either the person infringing on your arts will take it down, or they will keep it up and ignore you, or they will say that, you know what, actually I made this and I'm going to sue you, which is probably the worst case scenario, but that can happen as well.
It's a little bit of tactic of intimidation, right? Because you can write a normal person letter without any of the legal jargon and say like, hey, this is my art, can you please take it off? But if you took a template from like a legal website and made it sound a lot more formal, and on top of that you have a lawyer send it on your behalf, it sounds a lot more scarier, like you call it the scary letter, than just sending a regular note.
Yeah, you want to put a bunch of fear in them, and of course that's why they say the pen is mightier than the sword. Let's say they ignore you and you actually have to sue them. Suing is very stressful, so you got to think a couple times before whether or not you want to sue them. There's a financial cost to suing. Like I said, attorneys are expensive. Can you afford to even sue? Most artists can't, right? Because suing costs tens of thousands, if not hundreds of thousands of dollars. Do you have the time and emotional bandwidth to invest in a lawsuit? You know, this thing takes 1 to 3 years to get through. There's also a statute of limitations you have to consider, which means that once you find out that someone is infringing on your copyright, you have a limited amount of time before filing a lawsuit. And that depends on the state and what type of infringement is happening. And the way that your copyrighted work comes into play is in the proof part. So if you have proof that you filed your work with the US Copyright Office, then you can show that as evidence that you filed this and you have a right to this work and the other side does not. So one thing to think about lawsuits is whether or not it's worth it. Do you actually get justice, right? Because you spend hundreds of thousands of dollars or tens of thousands of dollars, 1 to 3 years to file a lawsuit. And let's say you win. You spent all this stress and all this time and all this money. You sue this individual or this company that's infringing on your lawsuit. And what happens if they just can't afford to pay you and they just go bankrupt? It's like, even if you win, you might not get anything out of it. So that's something I always tell people to think of before they sue. What I recommend is that you just send a cease and desist letter, and hopefully you can put some sort of fear into them, because it's the best bang for your buck that you can do. The next thing that we're going to talk about is our own copyright experience, and then we're going to talk about our copyright infringement experience. So as far as our copyright experience, the only thing that we have copywritten so far is this blanket. So because we were manufacturing this blanket overseas, we were afraid that somebody overseas might infringe on our copyright. So what we did was we filed a copyright for the entire design of Cathy's alphabet blanket in order to protect our right to that collage. And I strategically decided to do the entire collage instead of 26 individual paintings, because I didn't feel like filing 26 individual copyright filings for each one of her paintings and her other hundreds of, I don't know, thousands of paintings at this point, right?
Yeah, another reason we decided to copyright this particular design is actually per my manufacturing partner's recommendation. Since we were planning on selling it on Amazon, there's, you know, copyright infringement kind of goes rampant on Amazon. He recommended that we apply for copyright.
There have been several examples of people infringing on art copyright or using Cathy's art without her permission. I'll let her talk about that, and then we'll also talk about what we did in response.
Yeah, it's like scratching at my scab again, opening the wound. No, it wasn't that bad. Very recently, I was on Pinterest. I was just curious to see one of my popular designs, this fox. Was curious to see like what other people have pinned it, and as I scroll down, I noticed that one of them was from a Redbubble link. Redbubble is this online marketplace slash like licensing site that allows you to upload your art, and they will print and sell like products with your art printed on it, and you get a loyalty fee. I don't have an account with Redbubble, so I knew something was up because I definitely didn't license my work to Redbubble. After I clicked through, I saw that it was a seller from, I forget, it was like Spain or some other country, had a Redbubble storefront, and they were selling t-shirts with the fox printed on it, and they were reviews of customers that bought the t-shirt. 5-star reviews, along with other designs that didn't look consistent with each other. That implies to me that the seller has taken several people's art and made it into their own like e-commerce store or a Redbubble store.
And so to be clear, what they did is that they found Cathy's fox on the internet, took off her name, name and then sent it to Redbubble to make t-shirts out of it.
That piece of art usually has my signature or watermark on it. It was obvious that they removed that part of the art and uploaded just the art itself. So immediately I forwarded to my lawyer, like, help, what do I do? Can you send that scary letter?
Yeah.
I knew that much.
The cool thing with Redbubble and some of these bigger internet sites is that they have an established process to raise copyright concerns. What we did was just go through their process. They had a form that we could submit. So I just made a very simple letter that just basically said, hey, the link to this art, we have a copyright right to this art. This is a link to the original work. We are the artists. We did not give permission for this person to use it. Can you please take it down? We submitted it to them. They did some research or investigation and then they took it down. And then that was it. We were able to move on with our lives. What are some things that you learned? And I'll tell you about some things I learned from that experience.
We had a pretty good experience. Like you said, Redbubble got back to us within 2 days and everything went seamlessly. We haven't checked recently, but we know by the time we got the response, the link was taken down. So this is not to condemn Redbubble at all because they accept thousands of sellers every day. It's hard for them to do the due diligence of checking if every single piece of art that's being uploaded is legitimately the sellers, right? Do you feel like we kind of lucked out in that it was Redbubble? Wasn't someone's website that's not part of a larger marketplace? I think that would complicate things. They could completely ignore you and there's no one else kind of holding them accountable. And in which case we go back to your advice, which is like, how much is it worth it to you to keep pursuing and escalating?
Yeah. So my takeaways were that somebody needs to check every once in a while to see if any of our art is being used improperly. Second thing is that this is my first time having to send a cease and desist of this kind. Understanding that there's usually a process with these big companies, but there will be scenarios in the future where the process might not be as formalized and we'll have to figure it out how to handle that situation. And the third thing was seeing the silver lining. We'd never seen that fox on a t-shirt. So I was like,
we should make a t-shirt out of it.
I was like, this is pretty cool. Someone made a t-shirt and it is flattering in some ways because of the imitation and trying to find some humor or some silver lining in it.
It did not ruin my day to find out that's what happened. I kind of knew what the next steps were in general. It would upset me more if it was a large company that knowingly took my art and made it into a product and sold like tens of thousands of units. For some reason, that would anger me more than like a small guy.
This company is just us two for the most part, so we gotta really reserve our emotional health and what's gonna make us really upset because we can't let it throw us off our game. It was actually, in retrospect, a good experience to go through, and it helped to kind of inform everyone out there of what to do in these situations. So just to sum things up, copyright is automatically created when you make your work, as long as you can document that and you publish your work or put it into some physical or tangible form. Do not need an attorney to file a copyright with the US Copyright Office. You should be thoughtful of what you want to copyright because it does take some time and money, and you have some options if your copyright is infringed, but you should really be thoughtful before you sue.
Thanks for watching this video. If you enjoyed this and found it helpful, check out our other videos in our channel. We have legal videos, how-to, business tips, and other topics. Make sure to subscribe to our channel and share it with your creative friends if you think it'll help them.